Hello, my true crime lovelies. How are you? It is Thursday. I forgot to turn on a light. Hold on. Wait, there we go. Now you can fully see me. It's Thursday. It is June 12th. One of you lovelies hit me up last night and said that Judge Jackson has some orders that hit the docket. And sure enough, there are two. There are more coming. So I was waiting until this morning to see if they were going to hit, but we'll trickle them in. We're on verdict watch for Vallow, although it's 9:42 a.m. Eastern Daylight Time. So we're not officially like they're not in for another couple hours Mountain Time or whatever's going on in Arizona, but so let's talk about these. Let's talk about what's going on in Sarah's case. I have to admit, as it gets closer to her court date, and yes, I'm officially going to her hearing, or whatever trial, it gets more emotional for me. I think being pregnant and knowing how hard I had to work to be pregnant, not just with Sweet Pea, but with Sugar Bear. It was 5 years, six embryos, three miscarriages in the making. So I don't take being a mom for granted. I'm very grateful for my children, and it pisses me off. Sarah pisses me off that she's more worried about money and child support than her children and or than her child, and more worried about having him as a possession and not respecting him as a human being. It annoys me. It annoys me that Peter is helping her with that. It annoys me that Nicole is helping her with that. It just is. If it were up to me, she wouldn't have any rights as a parent. She doesn't deserve to be a parent, in my opinion, but it's just my opinion. There are lots of loving, deserving, really good moms out there, and she isn't one of them. She lied when she said she was an outstanding mother. Girl, what? Outstanding as in like a debt, as in something that is not good, but not, you know what I mean? Like, if, okay, we're just going to get into it because I think Judge Jackson is the judge for the case. And that's why I want to be there in person to see what goes down. In the meantime, I'm going to calm down. I'm going to play the intro. I'm playing the intro. I'm playing the intro for the person who keeps saying I don't announce that I'm playing the intro. It's playing now. I'll see you on the other side. All right, let's get into it. I have a new layout. Let me know what you think, although I know you will, but just I'm saying I'm encouraging it because I'm experimenting. 6:11. So yesterday, 8:56:13 a.m. This came in from Judge Jackson in the case of Brian C. Boone v. Sarah K. Boone, order after case management conference on May 29th, 2025. So we've gone over already some of the submissions that finally trickled in from Sarah. The judge is going to make orders, like full complete orders on everything that she either denied, granted in part, etc. And so as those come in, you and I will check them out. So on May 29th, for consideration during a case management conference, the parties having appeared and the court having reviewed the court file and being duly advised in the premises, finds and orders as follows. Parties appeared for the pretrial conference. Respondent Sarah K. Boone advised the court that she had mailed various motions that she wanted heard. The court reviewed the docket, but no motions had been filed. The court was, however, able to locate four motions mailed by or on behalf of respondent. Counsel for petitioner had not seen all the motions, but did not object to the court hearing arguments on each motion. because they weren't filed. The other counsel couldn't see it because if you guys remember when we looked at it, she did not send separate. These were handwritten. The majority, well, all the ones mailed from the jail. I don't know where Peter and Nicole were. And she didn't bother to write it twice. She just said, well, they'll get it when the court gets it. Well, if the court hadn't got it, Brian's counsel hadn't got it, right? Hadn't received it. But they didn't object, and so they were heard. So the court took the following action on the motions. Respondents motion for court to understand respondent's predicament regarding her financial affidavit and accept handwritten document being mailed in the meantime of actual received formally. Word salad of an uneducated person. That is what Sarah wrote as her headline or her, what is it called? The caption. And it was basically, we went over that. There's a video with Sarah on the cross. It was basically her complaining about how it was difficult for her because she murdered someone. And then respondents, and so that was granted, meaning, yes, not that the court will understand, but she was given leave to get this other form in, and in the meantime, to have this written one accepted. Why she just didn't send in the written one with a note on top, like, please accept, I haven't been able to. But in the video we went over, it's a simple Google search, right? So any of her flying monkeys could have Google searched it, or she could have just sent in the written one that she was going to send without all of this pages and pages of please feel sorry for me because I murdered my boyfriend. Respondents motion for court appointment of guardian ad litem to preserve and protect her parental rights. That was denied. So we'll see a full-fledged motion, I believe, or order coming about for that. Motion to compel mandatory compliance and enforce sanctions to petitioner and his counsel for direct violations of the pretrial conference order. That was granted in part, but it kind of backfired on Sarah because she was really the one that got in trouble for that, for not complying with that. Brian's team got admonished, but remember this one, that's why I marked it 3C, which also I don't know what happened here. Lowercase a, lowercase b, capital C. Somebody wasn't paying attention. And then we go back to lowercase d, but I marked that one. So just put that in your cap for a while. So then D, motion to compel petitioner for amended discovery responses and financial affidavit and enforce sanctions by the court for false information. Dated May 19th, filed May 30th, denied. I wanted to mark that too. So the mandatory compliance motion, that was also dated May 19th, filed May 30th. This one, motion for court appointment for the gal, was dated May 15th and filed May 30th. The other one was May 19th. I wonder if in the prison, like they mail it all out or file it out, or actually it's filed with the court on May 30th. So that's why they didn't have it, because this conference was on the 29th and those didn't get filed until the 30th. So it sounds like maybe, I don't know, somebody went into like the file room and found them and they were able to speak to them during the hearing. I'm not sure. They weren't officially filed until the day after the hearing. So here she says the court will issue separate orders on each motion. We thank you, Judge Jackson. We're looking forward to each order. Based on the court's ruling on the motion described in paragraph 3C, that's the one we put in our cap, respondent Sarah K. Boone was given 30 days from May 29th to prepare her pretrial statement that provides her position on the issues to be tried. So she's loud and wrong, right? She's complaining that Brian didn't partner with her, which is a valid thing, but then she also did nothing and just showed up to court to complain that he didn't follow the rules. Respondent also raised concern, and he sent it to her in enough time that she knew that she was going to have to do her own, but instead she just complained, he didn't do what you told him. Respondent also raised concern about petitioner not preparing an application required by the Department of Corrections so that the minor child could visit her. So this is outside of what their original motions were, right? Because she wasn't convicted when they filed their original motions, but she's bringing it up now as a complaint. She never filed a motion for him to participate in that. There was no pending motion before the court on this issue. So that's what I'm saying. She never filed a motion saying, let's have it so my son can come and see me. But petitioner did provide information to the court on his efforts in submitting the requested application. So he wasn't going to be in trouble either way because there was no motion. But Brian and his lawyers piped up and said, I did submit the application. He would follow up on the status of the application. So he's gone above and beyond what is required of him by the court. So again, it's showing his willingness to participate despite her saying, well, he didn't follow those directions to come and visit me and talk about this other thing. A trial final hearing date was coordinated for August 25th at 1 p.m. I'll see some of y'all there. The court will issue a separate trial order, done and ordered the 11th day of June, LaShonda K. Jackson. It was sent to Brian at his P.O. box, to Sarah at Lowell Correctional Institute, main unit, not annex where she is, and then to the attorneys, and to Isis Lee, the JA for the judge. Okay, then we're going to go over to this one. Let me make sure that's big enough for y'all. Oh, goodness. Okay. Also dated on the 11th, order granting in part respondents' motion to compel mandatory compliance and enforce sanctions to petitioner and his counsel for direct violations of the pretrial conference order set forth on April 28th. And this also was filed on the 30th, so the day after the hearing. This cause having come on May 29th for consideration of respondents' motion to compel, blah, 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 dated May 19th, filed May 30th. The parties have appeared, and the court having reviewed the court file and being duly advised in the premises finds and orders as follows. The motion to compel compliance is granted in part. Counsel for petitioner has been admonished for not petitioning the court to be relieved of the requirement for an in-person meeting of the parties to prepare a joint pretrial statement, given the dynamics of the location of the parties and counsel. So basically, they decided to not meet with her, and they just noticed the court, but they did not petition the court to be relieved of it, meaning ask for permission. Like, hey, because of these circumstances, we're not going to see her in person and we're just going to submit this. Is that okay? They just did it, right? So that's what they're being admonished for. But that's it. That's all. It's like a tongue lashing and then like, don't do that again. But for Sarah, she's got 30 days from May 29th to prepare her pretrial statement that provides her position on the issues to be tried. So she didn't really gain anything. And it's also a slap on the wrist of like, you could have done this by now. Instead of writing this letter to complain, you could have sent in your statement about your pretrial position. Why haven't you done that? You now have 30 days. I looked at it on the calendar. It's going to give her till about mid-July to do it. So it's plenty of time prior to their late August court date. But it's like she could have just done that in the first place. Maybe she gets her jollies that they're told next time don't do that. But nothing happened. And I think like the most important part out of all of this is she got smacked down and denied on he's lying about his financials, make him, she had no evidence on it. She had nothing to substantiate the lie, or as Judge Cranick would say, where is the lie? It's not there. And I'm sure it did not bode well that she's getting the information as reported by her from her teenage son. again, Brian's finances are not really a part of the equation other than it's required to turn in your financial information for consideration by the court. However, his petition to eliminate or reduce alimony is not based on his finances. His petition was based on a change in circumstances, which was Sarah becoming an incarcerated individual in 2020, right? And so she's still incarcerated. That hasn't changed. It doesn't change the underlying validity of his motion, irrespective of his finances, irrespective of the what he imputed to her, uh, even though she's not working, even though he's not working. Everybody cool your jets. That was just a hypothetical to get to a child support. Really, it was to get her to calm down because, like, ma'am, you're in there living off of the state, right? You're in the care and custody of the state of Florida. So you're living for free. You're not helping contribute to the household in which your minor child lives. Like, to give her a reality check, but instead she comes back with the $18,000 that makes no sense. I know some of you guys were like, no, she's trying to get him to pay it. I kind of get that, but he doesn't have the car, the Kia. She was awarded the Kia in 2018 when they got divorced. So she's left off of the trail when she gave it back to him or he took financial responsibility for it to be a liability or an asset. Like, that didn't happen. That's some fantasy in her head. So what she wrote on her finances, she's lying on hers, but she's accusing him. You know what I mean? Like, it doesn't make any sense. And the storage stuff had nothing to do with the divorce. That all happened afterwards. And so there's nothing on the record to even say like a $10,000 storage existed, whether that is the property that belonged in it. Did she deduct the cost of the storage that he would have paid out of pocket? Some of you guys are saying he stored it in his garage. I don't know that. If that's the case, I don't know why she called it storage. These heirlooms, it just doesn't make any sense. And I'm not going to give her any grace and try to infer what she meant to say, because she skipped a whole other part of, like, if I look at the dissolution of marriage, the Kia belongs to her. Some of you guys mentioned that Kelly Blue Book, it wasn't. She doesn't live in fantasy. I know we're all trying to ground it in reality. That car wasn't worth that much. And if it was sitting up, like, unless somebody was driving it or at least starting it once a week, uh, that car was worthless. And so I'm guessing, and it's totally a guess, that's why I'm prefacing it that way, that Brian tried to get her to allow him to sell the car and she refused, right? And that would have been a smart thing. Sell it, send her the money, or even, I don't think he could have sent it all at once. Just say he sold it for 2,000 or 4,000 or whatever. He couldn't have sent it to her all at once, but he could have used that to send it to her to get her zuzus and wham whams, right? And then he would not be removing money from the household in which he is raising his son as a single parent. She refused, and so he could not sell it because, again, he had no ownership of it since 2018. So the only thing he could do was scrap it, right? He's not going to leave it. If, say, it's stored on the property that he had, that he sold, he can't leave it there when he sells the house. So he scrapped it because she wouldn't sign over title. So that's on her. I feel pretty confident that he would have a paper trail of that, either a tablet message or a letter, something, back and forth, or recorded phone call, because he could legally record the calls on his own because it's already announced they're being recorded. Sarah's aware of that. That's two-party consent when he accepts a call. So he could have then done his own recording of the recording or of the call and have documentation of that. She refused to sell. She wasn't being reasonable. It's like her way or the highway. I don't know. I might be out on a limb there, but I'm just like trying to put it all together, knowing what we know about her now after reading all the text messages. Logic is not her friend. Logic is not her friend. She could have had that $4,000. It would have not taken out of his household. What would she have lost? I mean, when you get out, you have to get a new car anyway, ma'am. Like, if she would have taken the deal, it would have been 7 years later. It was what, a 2011 Kia? Um, You would have, I'm trying to think of like when she would have gotten out, like maybe 2030. You're not going to need a 2011 Kia. That makes no sense. But you weren't trying to get home anyway because you didn't take the deal. So, consequences, like learn what they are, get familiar with them. You're living with them either way. Too bad you didn't. I'm glad you didn't learn. I was going to say too bad, but you know what? I'm glad you're right where you belong, Miss Boone. You're right where you belong, despite all of your minions and flying monkeys professing otherwise. Would a more sane, reasonable person have deserved less than life? Absolutely. Would a remorseful person have deserved less than life? Absolutely. But you, Sarah K. Boone, you deserved life and you got life. So enjoy. All right, guys, that was my little rant to Sarah. I'm sure her monkeys will tell her only because they like to fly. The flying monkeys, the fly. No, only because they can't see for some reason. They haven't figured out how to send in a notarized copy of a document to get access to these family. Another YouTuber did. I saw Hear Me Out was reading family court documents. He figured it out. So I don't know, Peter and Julian, with all your fancy degrees, why you can't figure it out. So I know you're watching. You may not be watching this far, but figure it the F out. Actually, if you really figured it out, you'd leave her alone. But oh, and one of you guys in the comments said that Peter is not associated in any way with that animal sanctuary. Is he a giant catfish? I mean, the website is real. The Delapine Creative website is real, but there's no pictures of anyone, and I can't find pictures of them. I know I thought I had a picture of Peter, and Lana was like, that's not him. It's interesting. And he was not accepted by Florida DOC for visitation for something to do with his identity. So who is Peter Canto? That might be a little project that we go on, but we'll see. Anyway, I'll keep an eye out for additional things on the docket. I'm also docket watching Lori Vallow Daybell because apparently even in trial she's still filing motions that shouldn't be filed, and that's always fun. And yeah, oh God. We are going to go on a 12-step program, guys. I know I'm not saying we have to quit her overnight, but we're also feeding her, like we're giving her some narcissistic supply. And I want to be done with her this year. We'll say, I won't say a date other than by 12/31/2025, we will quit her. Let her rot old and alone. She's got a long time, long. I hope she lives a long life. That, all right. I didn't mean to be so ranty. I don't know what happened. But there it is. Let me know what you think down in the comments below. Toodles.